How you doing today? Yeah, everything is good. Everything is good my way. You know, I am that pimp. You know, and it's acronyms for priest, imam, minister, and prophet. And new school is the new school for the queens, or when we say queens and Elohim society, we say choiring. And what I'm reading now is the Constitution of Missouri. And basically, we're up to the actual Constitution of 1945. This is the revised. It was revised in 2006. So it's the revised 2000. It's the 1945 Constitution revised in 2006. So it's the 1945 Constitution of the state of Missouri. And the first thing that you have is a preamble. And the preamble statement says, "We, the people of Missouri, with profound reverence for the supreme ruler of the universe, and grateful for his goodness, do establish this Constitution for the better government of the state." And they said the source of the preamble, right, is the Constitution of 1875, which was the original Constitution. So within the constitutions, we have what they call Article 1, right, which is called the Bill of Rights. And it states, in order to assert our rights, acknowledge our duties, and proclaim the principles on which our government is founded, we declare. Now it goes into the sections, right? As I will read the sections. Section 1 is the source of political power, the origin, the basis, and the aim of government. That all political power is invested in and derived from the people. That all government of rights origin from the people. It is founded upon their will only, and is instituted solely for the good of the whole. Section 2 of the Constitution of Missouri states, promotion of general welfare, natural rights of persons, equality under the law, and purpose of government. That all constitutes government is intended to promote the general welfare of the people. That all persons have a natural right to life, liberty, and the pursuit of happiness, and the enjoyment of the gains of their own industry. That all persons are created equal and are entitled to equal rights and opportunity under the law. To give security to these things is the principal office of government, and that when government does not confer this security, it fails in its chief design. Section 3 of the Constitution of Missouri states, the power of the people over internal affairs, constitution, and form of government. That the people of this state have the inherent sole and exclusive rights to regulate the internal government and police thereof, and to alter and abolish their constitution and form of government whenever they may deem it necessary to their safety and happiness, provided such change be not repugnant to the Constitution of the United States. Section 4 of the Constitution of Missouri. The independence of Missouri. Submission of certain amendments to the Constitution of the United States. That Missouri is a free and independent state, subject only to the Constitution of the United States. That all proposed amendments to the Constitution of the United States qualifying or affecting the individual liberties of the people, or which in any wise may impair the right of local self-government, belongs to the people of this state, shall be submitted to conventions of the people. Section 5 of the Constitution of Missouri. Religious freedom and liberty of conscience and belief and limitations. That all men have a natural and indefeasible right to worship Almighty God according to the dictates of their own conscience. That no human authority can control or interfere with the rights of conscience. That no person shall, on account of his religious persuasion or belief, be rendered ineligible to any public office or trust or profit in his state, in this state, be qualified for testifying or serving as a juror, or be molested in his person or estate. But this section shall not be construed to execute acts of licentiousness, nor to justify practices inconsistent with the good order, peace, or safety of the state, or with the rights of others. Section 6 of the Constitution of Missouri. Practice and support of religion not compulsory. Contracts therefore enforceable. That no person can be compelled to erect, support, or attend any place or system of worship, or to maintain or support any priest, minister, preacher, or teacher of any sect, church, creed, or denomination of religion. But if a person shall voluntarily make a contract for such object, he shall be held to the performance of the same. Section 7. Public aid for religious purposes. Preferences and discrimination on religious grounds. That no money shall ever be taken from the public treasury, directly or indirectly, to aid any church, sect, or denomination of religion, or in aid of any priest, preacher, minister, or teacher thereof, as such that no preference shall be given to, nor any discrimination made against any church, sect, or creed of religion, or any form of religious faith of worship. Section 8. Freedom of speech. Evidence of truth and defamation actions. Province of jury. That no law shall be passed impairing the freedom of speech, no matter by what means communication, that every person shall have a free to say, write, or publish, or otherwise communicate whatever he will on any subject, being responsible for all abuses of that liberty, and that in all suits and persecutions for libel, or slander, the truth thereof may be given in evidence, and in suits, prosecutions, for libel, the jury, under the direction of the court, shall determine the law and the facts. Section 9 of the Constitution of Missouri, the Bill of Rights. Section 9, the rights of peaceable assembly and petition. That the people have the right peacefully to assemble for their common good and to apply to these invested with the power of government for redress of grievances by petition or remonstrance. Section 10, due process of law. That no person shall be deprived of life, liberty, and property without the process of law. Section 11, institution for debt. That no person shall be imprisoned for debt except for non-payment of fines and penalty imposed by laws. Section 12, habeas corpus. That the privilege of the writ of habeas corpus shall never be suspended. Section 13, ex post facto laws. Ex post facto laws. Impairment of contracts in irrevocable privileges. That no ex post facto law, nor law impairing the obligation of contracts, or the retrospective of its operation, or making any irrevocable grant of special privileges or immunities can be enacted. Section 14, open courts, certain remedies, justice without sale, denial, or delay. That the courts of justice shall be open to every person, and certain remedies afforded to every injured to person, property, or character, and that the right and justice shall be administered without sale, deny, or delay. Section 15, unreasonable search and seizure prohibited. Context and basics of warrants. That the people shall be secure in their persons, papers, homes, and effects from unreasonable search and seizures, and no warrants to search any place or seize any person or thing shall be issued without describing the place to be searched, or the person or thing to seize, as nearly as may be, nor without probable cause supporting by written oath or affirmation. Section 16, the grand juries. Composition, jurisdiction to convene powers. That a grand jury shall consist of 12 citizens, any 9 of whom concurring may find an indictment on a true bill, provided that no grand jury shall be convened except upon an original order of a judge of a court having the power to try and determine felonies. But when so assembled, such grand jury shall have powers to investigate and return indictments for all character and grades of crime, and that the power of grand juries to inquire to the willful misconduct in office of public officers and to find indictments in connection therewith shall never be suspended. Section 17, indictments and informations in criminal cases, exceptions. That no person shall be prosecuted criminally for felony or misdemeanor, otherwise than by indictment or information which falls, which shall be concurrent remedies. But this shall not be applied to cases arising in the land or naval forces or in the militia, with no actual service in time of war or public danger, nor to prevent arrest and preliminary examination to any criminal case. Section 18A is the rights of accused in criminal prosecution. That in criminal prosecution the accused shall have the right to appear and defend in person and by counsel, to demand the nature and cause of the accusation, to meet the witnesses against him face to face, to have process to compel the attendance of witnesses in his behalf, and a speedy public trial by the impartial jury of that county. Section 18B, depositions in felony cases. Upon a hearing and finding by the circuit court in any case wherein the accused is charged with a felony, that it is necessary to take the deposition of any witnesses within the state, other than defendant and spouse, in order to preserve the testimony, and on condition that the court makes such orders as will fully protect the rights and personal confirmation and cross-examination of the witnesses by the defendant. The state may take the deposition of such witnesses, and either party may use the same at the trial, as in civil cases, provided there has been substantial compliance with such orders. The reasonable personal and travel expenses of defendant and his counsel shall be paid by the state or county as provided by law. Section 19. Self-incrimination and double jeopardy. That no person shall be compelled to testify against himself in a criminal court, nor shall any person be put again in jeopardy of life or liberty for the same offense, after being once acquitted by a jury. But if the jury fail to render a verdict, the court may, in its discretion, discharge the jury and commit or bail the prisoner for trial at the same or next term of count. And if judgment be arrested after the verdict of guilty on a defective indictment or information, or the judgment of a verdict of guilty be reversed for error in law, the prisoner may be tried anew on a proper indictment or information, or according to the law. Section 20. Bail guaranteed exceptions. That all persons shall be bailable by sufficient sureties, except for capital offense, when the proof is evident or presumption great. Section 21 of the Bill of Rights of the Constitution of Missouri. Excessive bail and fines, cruel and unusual punishment. That excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Section 22A, the rights of a trial by jury, qualification of juries, and 2/3 of the verdict. That the right of the trial by jury, as therefore enjoyed, shall remain in invalid, provided that a jury for the trial of criminal and civil cases in courts not of record may consist of less than 12 citizens, and as may be prescribed by law, and a 2/3 majority of such number concurring may render a verdict in all civil cases, that in all civil cases in courts of record 3/4 of the members of the jury concurring may render a verdict, and that in every criminal case any defendant may, with the assent of the court, waive a jury trial and submit the trial of such case to the court, whose finding shall have the force and effect of a verdict and a jury. Section 22B, female juries optional exemption. No citizen shall be disqualified from jury service because of sex, but the court shall excuse any woman who requests exemption therefore before sworn as a juror. Section 23, rights to keep and bear arms, exceptions. The right of every citizen to keep and bear arms in defense of his home, person, and property, and when lawfully summoned in aid of civil power, shall not be questioned, but this shall not justify the wearing of concealed weapons. Section 24, subordination of military to civil powers, quartering soldiers, that the military shall be always in strict subordination to civil power, that no soldier shall be quartered in any house without the consent of the owner in the time of peace, nor in time of war, except as prescribed by law. Section 25, elections and right of suffrage, that all elections shall be free and open, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. Section 26, compensation for property taken by eminent domain, condemnation, juries, payment, and railroad property, that private property shall not be taken or damaged for public use without compensation. Such compensation shall be ascertained by a jury or board of commissioners for not less than 3 freeholders in such manner as may be provided by law, and until the same shall be paid to the owner or into court for the owner. The property shall not be distributed, or the property rights of the owner therein divested. The fee of land taken for railroad properties without consent of the owner shall remain in such owner's subject to use for which is taken. Section 27, acquisition of excess property by eminent domain, disposition under restrictions, that in such manner and under such limitations as may be provided by law, the state or any county or city may acquire by eminent domain such property or rights in property in excess of that actual to be occupied by public improvement or use in connection therewith, as may be reasonably necessary to effectuate the purposes intended, and may be vested within the fee simple title thereto, or the control of the use thereof, and may sell such excess property with restrictions as shall be appropriated to preserve the improvements made. Section 28. Limitations on taking of private property for private use. Exceptions. Public use as judicial question. That private property shall not be taken for the private use with or without compensation unless by consent of the owner, except for private ways of necessity, and except for drains and ditches across the land of others for agricultural and sanitary purposes in the manner prescribed by law, and that when an attempt is made to take private property for a use alleged to be public, the question whether the contemplated use be public shall be judicially determined without regard to any legislative declaration that the use is public. Section 29. Organized labor and collective bargaining. That employees shall have the right to organize and to bargain collectively throughout representation of their own chosen. Section 30. Treason. Attainder, corruption of blood and forfeitures, estate of suicides, death by casualty. That treason against the state can consist only in levying war against it, or in adhering to its enemies, giving them aid and comfort. That no person can be convicted of treason unless, on the testimony of two witnesses to the same overt act, or his own confession in open court. That no person can be attainted of treason or felony by the General Assembly. That no convictions can work corruption of blood or forfeit of estate. That the estate of each person as may destroy their own lives shall descend or vest as in cases of natural death. And when any person shall be killed by casualty, there shall be no for failure by reason thereof. Section 31. Fines or imprisonment fixed by administrative agencies. That no law shall delegate to any commissions, bureau, board, or other administrative agency authority to make any rule fixing a fine or imprisonment as punishment for its violations. Section 32. Crime victims' rights. 1. Crime victim, as defined by law, shall have the following rights as defined by law. 1. The right to be present at all criminal justice proceedings, and whether the defendant has such rights, including juvenile proceedings where the offense would have been a felony if committed by an adult. 2. Upon request of the victim, the right to be informed of and heard at guilty pleas, bail hearings, sentences, probation, revocation hearings, and parole hearings, unless in the determination of the court the interests of justice require otherwise. 3. The right to be informed of trials and preliminary hearings. 4. The right to be restituted, which shall be enforceable in the same manner as any other civil cause of action or otherwise provided by law. 5. The right to a speedy disposition and appellate review of their cases, provided that nothing in the subdivision shall prevent the defendant from having sufficient time to prepare his defense. 6. The right to reasonable protection from the defendant of any person acting on behalf of the defendant. 7. The right to information concerning the escape of an accused from custody or confinement, the defendant's release, and the schedule of the defendant's release from incarceration. And the right to information about how the criminal justice system works, the rights and the availability of services upon request of victims, the right to information about the crime. Nevertheless, 2. Notwithstanding Section 20 of Article 1 of this Constitution, upon the showing that the defendant possessed a danger to a crime victim, the community, or any other person, the court may deny bail or may impose special conditions whether the defendant and security must guarantee. 3. Nothing in this section shall be construed as creating a cause of action for money damages against the state, a county, or municipality, or any of the agencies, instrumentalities, or employees provided by the General Assembly, or employees provided that the General Assembly may, by statutory enactment, revise, modify, and supersede any judicial decision or ruling arising from any cause of action brought pursuant to this section. Nothing in this section shall be construed to authorize a court to set aside or to void a finding of guilt on acceptance of a plea of guilty in any criminal case. 5. The General Assembly shall have power to enforce this section by appropriate legislation. This is adopted November the 3rd, 1992. Section 33. Marriage, validity, and recognition. That to be valid and recognized in the state, a marriage shall exist only between man and woman. Section 34. English to be the official language of the state. That English shall be the language of all official proceedings of the state. Official proceedings shall be limited to any meeting of a public governmental body at which any public business is discussed, decided, or public policy formulated, whether such meeting is conducted in person or by means of communications equipment, including but not limited to conference calls, video conference, internet chat, internet message board. The term official proceeding shall not include an informal gathering of members of a public governmental body for ministerial or social purposes, but the term shall include a public voice of all or a majority of the members of a public governmental body, by electronic communications or any other means, conducted in lieu of holding an official proceedings with the members of the public governmental body gathered at one location in order to conduct public business. This was adopted November 4th, 2008. Thank you.